our contempt calendar this morning. These are official court proceedings. These are public proceedings. These hearings are streaming live on YouTube. Because these are official court proceedings, you must adhere to and abide by professional courtroom decorum. So that means present yourself and behave as if you were physically in the courthouse. That means no smoking, no drinking, no driving, no eating, no lying in bed. Can't be at the dentist's office, can't be at the doctor's office. Find a place where you're comfortable, be seated and be still. Please be mindful of your background noise and your background environment.
Take about an hour
Okay.
for our side.
All right. And then for Miss Habib, how much time? Miss Bouvier. How much time are you requesting? Miss Bouvier, I thought I saw. Okay. I can't see you at this juncture, and your video, and your sound is on mute.
5 minutes. 10 minutes.
All right, and then we do have our guardian ad litem who will be called first as court witness. All right. And then we have the matter of Rhett versus Fox. How much time are we requesting on that matter, Ms. Rhett?
I'm sorry, good morning.
Good morning. How much time to present the issues that you have?
10 minutes.
All right. And what about you, Mr. Fox?
I'm guessing 5 minutes.
Okay, 5 minutes. Are you consenting to the numbers? It's a lot to, it's just a short amount of time.
I'm not sure what the matters are about today.
Honestly, nor am I.
Okay, well, it was on,
To be honest.
to get here, you would have had to do something. So did you file? Because I remember that initially this was dealing with child support contempt, I thought, because it was initially on a child support matter calendar, and then I let it roll over to the child support calendar. But your position is there's no desire that you have with the court, Ms. Rhett?
We, when we came to you initially, it was for the contempt for his visitation and everything like that. And then as of May, I believe it was the end of May, we got an email saying that I guess this was a follow-up or something.
Okay, I'll leave it there and then we'll figure out where we are, but okay. Okay, I had a chance to go back through the file on Rhett versus Fox. So when the matter first came in, Ms. Rhett, you did file a contempt. You filed a contempt for failure to pay child support and supervised visits. And it looks like...
And his visits at all. It was not supervised anymore. It was just his regular weekend visits and stuff. It wasn't supervised anymore. It was just his regular visits that he wasn't doing.
His regular visits. I see. But so, yeah, I'm not sure exactly what you noted down, what you meant, but I'm just reading what you wrote. You wrote supervised visit. Mom was there for pickup, not drop off. That's what you wrote.
Mm-hmm.
And then I'm assuming I'm looking at the order that I wrote, and it says something about the timing. And then it says father's mother, Melissa Fox, shall be the supervisor and the child shall remain in her presence for the duration of the visit. Upon completion of the reunification period, visitation period, the party shall abide by the schedule and the parenting plan. That's what was written. Okay.
Mm-hmm.
Right. And so your position is that mom was supposed to be there for the entire duration, which is in here, but she wasn't, and you had some concern.
Yes.
All right. Now that issue was never resolved because what appeared to be the larger issue was the issue of child support that he was behind. But I noticed that he had a child support matter that was coming up on my other calendars. And that's why I pushed this whole case off so that could be resolved. Mm-hmm. I'm looking at that order and it looks like they did handle it and they put him on a arrearage payment of $50 a month on those outstanding arrearage, which is about $2,300. Do you understand that to be the case?
Yes, ma'am.
Okay.
I didn't know that, but yeah. Okay.
Okay. Yeah. So look, 23 CH 1046, that was the number. That's the case number of the case dealing with the arrearage. At the time, the department believed that he was in arrears of 1908. But by the time it was resolved, he was in arrears by the amount of 2389.71. And they said that amount would be paid back to you at a rate of $50 per month. So you'll get $477 plus $50. That's what you're supposed to be getting. And if you're not, you need to call down there and kind of figure it out because that's the final adjudication of the matter on related to that case.
Okay.
All right. Now, let me take a look. So the only issue is, have you all finished the reunification? Like are you regular visitation, or are you still on supervised visitation?
We did supervised visitation for a month, and that was about last year this time, end of June going into July. And then from there forward, it was every other weekend. When I did the contempt, it was because he was not getting them on his weekends, or I would show up and he wasn't there, or when I would text him or something like that to see where he was coming, he wasn't coming. And then when we came back here in January or February of this year, I don't remember if it was you or it was a different judge, but told him that he could at least make some effort to at least take him to the park or something like that, because he stated that his mom didn't want any more kids at the house and stuff like that.
Yeah. Yes, that was me. So, with regard to visitation, are you having any issues that the court need to take up now, or are you satisfied with where you are? And with regard to the child support issue,
I'm over it. He still hasn't gotten him.
he still hasn't picked them up.
He still hasn't. And I spoke with the mother, because I have since taken myself back to school and gotten my certification for medical coding. And I had a meeting that I needed to go to. And I reached out to him and his mother, asking if Jordan can come over there for a few hours. He never answered. And the mother answered me back and told me that she never had a problem with Jordan coming to the house. And he's always welcome. And if I ever need her, to let her know. So I just realized he does not want to be bothered.
Oh, because the mom said that was not her issue about having kids over, and Jordan is welcome. Did you take Jordan to her?
No, she had actually, it was her daughter's birthday weekend. So
Okay.
she said she had something to do. So I found another friend to work some for me.
Okay. So at this juncture, there is no visitation because Mr. Fox is not participating.
No.
All right. And Mr. Fox, your position was you couldn't participate because you didn't have a place to take them. Your mother has made that clear that she doesn't have that issue. So why aren't you participating?
Ma'am, my mother may have told her one thing, but told me another.
And that's
So
I'm not even being bothered.
I haven't even had any contact to even, I don't even know why or how they even went on, because like I said, mother's telling me one thing and may have told Ms. Red something else some months ago.
Well,
This
I
ain't
mean,
been nothing.
like that. You and I talked about public places, like just getting your kid for the day, taking them to the park, play basketball, to a movie or something in public. Why haven't you at least participated or tried to visit him in a public space for a few hours?
Yes, ma'am. I've reached out to Ms. Red on multiple occasions. It's just been a conflict of schedules between me and her. I've had to change my number here recently. I can just show you the messages where I've reached out twice this week alone to get Jordan, and didn't get any type of response at all. So I've been reaching out. Like I said, it's just a conflict of schedules between me and Ms. Red. There's no
Yes,
problem
ma'am.
or anything.
I didn't know that was you. I saw the messages, but this just says, can I get Jordan? I don't know that until you said it just now, I didn't even know you had a new number.
I wouldn't know who else would be asking about my son other than his dad. So
Okay.
Okay.
All right. So I think you guys need to start working better together for Jordan's sake. So you need to follow the order, though, to make sure you're doing the visitation properly. Mom seemed to have changed her mind. So maybe that's okay. I'll tell you what, why don't you call your mom and Miss Red, and you all come to an understanding as to what will be allowed and what would not. That way we could just cut out the middleman and just handle it. Like, I just, figure out, say, Mom, I have Miss Red, I have, Kiwana on the phone. We just want to make sure it's okay for Jordan to come over. If she says yes, there you go. All right. You don't have to worry about that anymore. All right.
Yes,
and so that you can start having some relationship with your child and stop deferring it. And like I said, this is very simple because you can do stuff in public until you have a place to take your child, but don't miss this opportunity. How old is the kid?
He'll be 3 in September.
How old?
He'll be 3 in September.
3. Okay. Well, I guess he can't play basketball, but you can take him to Chuck E. Cheese.
Yes,
all
he
right.
does.
yes, ma'am. I had been seeing him up until like early February. Then that's when the thing with my mother started. So it was like around January or February or so.
Mr. Fox has not gotten Jordan ever since November.
It looks like she may have changed her tune. Your situations may have changed, but I'm just saying, don't lose the the opportunity interest that you have with regard to your kid, okay?
Yeah,
All right,
he
so it
has
looks like
Ma'am,
all
like she stated, like she saw my messages and she just didn't know it was for me. So like you stated, it's like she stated, she saw 2 messages from me trying to get him. So I'm not trying to not get him, but she didn't know it was me, like she said.
Your Honor, he's not gotten him since
I'm
November of
sorry.
last year, and those messages
That's
came
not
this
true.
week. This is the first
That's
time
not
I've heard
true.
from him
I
in
got other
months,
messages
since
on my
March.
phone.
Okay.
No, ma'am.
Mr. Fox, just reach out and continue to reach out
problem.
to try to have some time with your kid, okay?
No problem.
Thank you, Your
Yes,
Honor.
yes.
All right, thank you. Y'all take care. All right, now we're gonna
You
move
too.
to bid versus Bouvier. All right, so remember when we last came on this matter, there were some issues that had come up that the court was not quite aware of. I think it may have been the reports. I had not yet read them. And some of the things that were being said, I wasn't familiar with. So I asked everybody to come back so that I can read through those reports and have a better understanding of the backgrounds of everybody. And so I've had a chance to.
Your Honor,
Oh, okay. Give me. Okay, so as I was saying, so the court had an opportunity to review those and has a better understanding of background. I can't remember exactly how far we got in there. I don't know if Ms. Giles even made recommendations at that time. I don't think we got that far, but I'm not sure if you all remember or not. But I have read the recommendations in the report.
I don't think we got that far last time, Your Honor.
Okay, all right. So the let's see. So since I have that background, let me start by calling Ms. Giles. All right, and if you would, you have Ms. Bouvier. Ms. Bouvier, you need to turn your video on because we're in the middle of trial. Middle of the hearing now. So you have to have your video on. You turn your mic off, but your video needs to be on.
Your Honor, for the record, before we proceed this matter, there are some facts I must state for the record. I'm here on special restricted appearance as the representative of the descendant. And I do not wish to waive any rights, rather statutorial or procedural. And for the record, as the authorized representative, executor, beneficiary, I have demanded a jury trial in regards to this matter. Moving forward, for the record, Your Honor, I have filed an amended notice of recusal with an affidavit of fact on May 29, 2024. With all due respect, Your Honor, I have not received a response from you in regards to this notice. Please note for the record, I have presented to this court on special restricted delivery all presentments to date. Moving forward, according to Georgia Code Section 1512-122 and 2020 Georgia Code Section 91138, rights to a jury trial is a reserved right. Please note for the record, at this time, I do not wish to add nor subtract anything from my presentments, and I stand behind my documents. And at this time, I respectfully excuse myself from this proceeding to await all notices concerning the trial by jury according to the law.
Okay. So first, you filed a motion for recusal, which the court denied. Looks like you filed, you need to turn your video back on. If you don't turn your video back on, I'm going to have a hearing without you. Okay, so turn your video back on. All right. You filed a motion for recusal, which the court reviewed and denied without there being sufficient evidence. I think you filed an amended one, which the court did not receive a copy of. You were supposed to send that to Chambers if you actually wanted me to respond to it. But you filed it via e-file. I'm noticing it now. It's going to be denied for the very same reasons. With regard to your request for for a trial, this is a custody matter. It cannot be a trial by jury because you can't have a trial by jury on a custody matter. So that issue would be denied. As for your representation, the court will consider you London Bouvier. That's who you are. That's what the court consider you as. If you want to consider yourself as anything else, that'll be up to you. But when I make a decision, it's going to be for your government name, London Bouvier. And that's what the law of Georgia is going to hold accountable. So when you don't do what I asked to do, your representative or whoever you think you might be won't be going to jail. It'll be you, London Bouvier. Okay. So I want to make sure you understand that. So is that clear to you? All right, we're going to proceed in these proceedings. If you want to participate, that's up to you. If you don't want to participate, that's up to you. But I am going to make a ruling, and the law will be what the law is. I suggest you should participate so that you can be heard, and that the concerns that you have, the court will have an opportunity to hear them. That'll be up to you. Okay. But if you do participate, you need to have your video on. Ms. Giles?
Yes, Your Honor.
Start with your recommendation first, and then you can back up with why you make such decision.
Sure. And I think we're just here on the limited matter for contempt from that interim order that was entered in April, if I'm correct. And I agree with that, what's in that order, Your Honor, as far as getting visitation started
Okay,
from
hold on.
Elaine and Dad.
Yeah, hold on. Let me pull back for a second, okay? Because I think I had to go to another case file to see those. Okay, so there's looks like what date was that?
The interim order was entered on April 19th.
April 19th.
So we were here, I think, April 16th for the hearing.
Okay, let me
That's
see.
right, yeah.
Okay, so I see I see on April 19th, amended parenting plan. So-
No, Judge, we had the hearing, I believe, on the 14th. We submitted an interim order for a temporary visitation that was signed on the 19th.
That's signed on the 19th.
That's correct, Your Honor. I'm sorry, it was signed on the 18th and filed on the 19th.
Did you get a copy of it? Obviously.
Yes.
Yeah,
Okay, I don't see it. Hold on for a second. Did you see it in the? It's not showing in Judge's edition. Okay, I apologize. So there are two things. There's Odyssey that everybody kind of looks at, and then there's Judge's edition, which is how we keep our notes based on a document, which is how we operate. I don't know why, but this interim order isn't there. So when I was reviewing the file for this hearing, I didn't see this order. So let me take a quick second to look at it. Thank you.
no problem, Judge.
Has this order been followed? Is it
No,
being?
Your Honor,
Yeah.
that's why we're here.
It's not being followed.
No, right. We filed a contempt on this order on May 7th.
Really? I don't know what's happening. Okay. I had thought that this matter was coming back on the calendar because I continued it from the last matter, but now I understand. Okay, so there is also the contempt on the interim order.
That's
right.
correct, Your Honor.
Got it. I got it. All right. Yeah, all other issues shall remain. Okay. All right. So the order isn't being followed.
That's
It is
correct.
not.
That's the issue. It being followed at all, like no visitation, or just being
No visitation at all, Judge.
all right, Ms. Bouvier, I've indicated to you once before that your video has to stay on. This will be my last warning to you. Turn your video on. Ms. Bouvier, if I say it again, I'm going to find you in contempt of court. If I say it again, I'm going to find you in contempt. So when any issue happens before, I'm going to have my deputies come get you. Okay. You turn it off again, I will find you in contempt of court. All right. So you will spend 10 days in the DeKalb County Jail. You turn the video off again. Okay. Did you understand me, Ms. Bouvier? Did you understand me, Ms. Bouvier? Unmute yourself and say so. Ms. Bouvier, I'm going to ask you one more time. I'm going to excuse you from this hearing. I'm going to find you in contempt, and I will pick you up. And your child will then go to Mr. Bouvier. Unmute.
I stand behind my documents. For the record, I stand behind my documents.
You can stand behind whatever you want. Do not unmute like I asked you. Ms. Marshall, go ahead and remove Ms. Bouvier from these proceedings.
Yes, ma'am.
I find you in contempt of court, 10 days in the DeKalb County Jail. Child will be presented to Mr. Bouvier. These matters will be continued thereafter. All right.
Thank you, Your Honor.
All right. You all have a good day.
You too, Your Honor.
All right.
Judge, do you want me to prepare an order for instant?
Prepare the order, put it in Word so I can put in my contempt, but interim the custody of the child will be sent to Mr. Bouvier.
Thank you, Judge.
So
Thank you.
Miss Chelsea knows I see her present. I see Mr. Jeremy Knowles present. I see Ms. Panich present as well. So everyone is here. This is on contempt matter. Ms. Panich, you may proceed.
Thank you, Your Honor. I have a brief opening. We're here, and I would say that my paralegal Rachel Newbill is on, and she will be handling the exhibits. So if she can be invited to share the screen when it's
All right,
time.
Ms. Marshall, if you'll give Ms. Newbell opportunity to give her the ability to share.
Yes, ma'am.
All right.
Thank you. Okay. Judge, why are we here? In a pattern that we've seen throughout the history of this case, Jeremy Knowles only does what and when Jeremy Knowles wants to do. Doesn't matter what the sanctions are. If he doesn't want to comply, he simply won't. This court previously held him in contempt of its temporary orders. I believe there were 5 grounds of contempt the court found, and found his prior testimony unreliable, inconsistent, and self-serving. So it's no surprise we're back here. Today, we find that Jeremy paid none of his financial obligations as ordered per the final judgment, not child support, not attorney's fees, and not cooperating with the property he is still trying to get back to be assumed by Ms. Knowles as ordered by the court. We tried to resolve all these contempt issues by asking
Say none of them?
none of them as ordered. There are sometimes he paid very late, but he's still very behind. I mean, that was essentially one thing he paid, which was in arrears, and that was late. We tried to resolve this without court intervention by asking, because he delayed issues related to the assumption that she could assume the marital estate, assume the mortgage for the marital residence. We asked for an extension because it was 120 days and he had delayed producing some documents, which caused a delay in the assumption process. And we offered to reduce the amount of equity owed to him in the marital estate by the amount he has failed to pay. So he wouldn't have to come out of pocket. He was fine with reducing the equity, but he was not okay with extending the assumption. So my client, at great significant legal fees by bringing us involved, was able to hasten the assumption process, had a closing date for the last day, and Mr. Knowles didn't show up. So don't forget, the mortgage was in his name. He had to show up in order to sign it over. He's also removed the child from the state without following the court order. We needed to file an emergency motion for the conveyance of the house so that she didn't lose the ability to assume the mortgage at the lower interest rate. It's ready for the assumption. He needs to sign the document so she can calculate what equity he is still owed and pay him. She can't do that without having the house in her name, so she can then get either a second mortgage or at least know what she owes him. So we have that issue. And this wasn't on our notice, but Judge, we filed a 9/15/14 motion in February. It has gone unresponded to. We believe it's right to be ruled on.
Okay. Mr. Knowles. Unmute.
Yep, I'm here. Thank you for hearing us today. In regards to Ms. Panage's claims of Chelsea not being able to assume the mortgage, she was approved to assume the mortgage on 2 days before the 120th day set by the court. The mortgage, where the house has 2 mortgages on it. The first one she was approved to assume. The second one is non-assumable. As Ms. Panage stated, everything is solely in my name when it comes to the mortgage, but Chelsea does own the property. Her name is on the title and deed. It is not on the mortgage. She does not need the mortgage to get a second mortgage on the house. She is the co-owner of the property. So at closing, she could have the second mortgage queued up to pay off the balloon payment and also pay my equity at closing.
Mr. Knowles, why were you not at closing? Let's just get straight there, okay?
Because the conditions of the order were not met.
And what condition was that?
That my name be removed from all aspects of the property.
Well, how can she do that if you don't go to the closing?
She does that in advance of the closing. All the documents
Who
queued up.
would do that, Mr. Knowles?
The mortgage company.
That doesn't make sense.
The mortgage company. She would get approved to assume the second mortgage.
You think she's going to remove your name off the documents prior to the closing?
No, this is all happened at closing
But you were not at closing.
because all the documents were not prepared.
Oh, so the closing attorney canceled it because the documents were not prepared?
No, she cannot assume the second mortgage, and this is by HUD's regulation. So the second mortgage has to be paid off in full at closing. She was
But you
not.
didn't attend the closing.
Huh? Sorry? So the second mortgage has to be paid in full at closing. To do that, Chelsea would need to take out a second mortgage solely in her name to remove my name from the mortgage. This all happens concurrently, all at the same time. I sign this document, it pays off this loan, she gets the house, I get the equity, the remaining balance, all at the same time. Because the second mortgage on the property is non-assumable. If she were to assume the first mortgage and pay my equity and remove my name, I would still own wholly the second mortgage. and not the property. And that cannot happen based off of HUD's regulations, not mine.
So
So-
HUD told you not to go to the closing.
The documents were not prepared to remove my name from the second mortgage at closing.
Okay.
Your Honor, just to be clear, there is no second mortgage. There's a balloon. And my client cannot resolve that without her name also being on it. And that would only happen through the assumption.
Her name cannot be on the balloon payment. It is non-assumable and has to be paid off at closing in full. It is a non-assumable loan. Ms. Spinach is speaking incorrectly. I have all the documents and exhibits from ISN. They're all serviced by Mr. Cooper.
Okay. Ms. Spanish, call your first witness.
Your Honor, I call Chelsea Knowles.
All right, Ms. Knowles, raise your right hand. All right, you may proceed, Ms. Spanish.
Thank you. I'm just going to cut straight to this, what you just heard. Can you clarify what's the difference between the first and second mortgage and what you were prepared to do?
Yes. So I was fully approved for the loan through Mr. Cooper, who currently services the loan. And I was told by Mr. Cooper that they only handle the assumption. The balloon payment Jeremy is referring to, not related. We even had that in an email. And even Mr. Cooper stopped responding to Jeremy because he continuously would email them over and over and over about matters that don't involve Mr. Cooper. I went through the process, Judge. I went through the income verification, the credit process, provided documentation showing that I've been paying the mortgage for 2 years out of my bank account. I always paid the mortgage when we were together out of my bank account. So it was very easy to produce documents because I continued to do so, even when I wasn't living at the property. So I only had to produce 6 months of me paying the mortgage. I was fully approved based off of my income and my credit, and I was able to assume the loan with the same interest rate. The mortgage company pulled up the quitclaim deed. The quitclaim deed is literally already ready, just needs to be signed. I told Jeremy this. We even talked about equity. We provided him with an equity payout calculator. We even tried to resolve this before coming to court and wasting time. We made an offer. He came back with some ridiculous calculations. I'm not even sure what they mean, but long story short, I was fully approved for the loan. Mr. Cooper is aware of the balloon and still said it wasn't an issue. They still approved me for the loan and told
Okay,
me.
so the balloon, what was the loan? What's owed on the house?
The principal left is, I think, $302,000.
Okay, 302,000. And does that 302,000 include the balloon?
No,
Okay, what's the balloon amount?
the balloon amount is $50,000.
Okay, so what happens to the 50,000?
So once I actually own the property, then I can go to the balloon servicer. The balloon does not have to be resolved until the property is actually sold. That was the terms of the agreement. So what the balloon is, it's a COVID relief payment that
It's
we
a COVID relief payment that, yeah.
Right.
Okay,
And so we
when
don't
the
have
house
to,
is sold, you have
then
to pay
we have
it.
to pay it. It has nothing to do with this process.
Right, okay. So it was that COVID relief money, so that, yeah, okay, so when you sell the house, that 50,000, it will attach, okay.
Yeah.
But I think Mr. Knowles' position is that the 50,000 has his name attached to it.
And
Okay,
he's right,
all
because
right,
it's also attached to the mortgage. But
right,
until I own the mortgage, then I can go to them and say, hey, this is now my debt.
okay,
They won't even talk to me because I'm not on the mortgage. Like I had to get authorization from even Mr. Cooper, even though I'm on the deed, they wouldn't even send me any paperwork because I wasn't on the mortgage.
right, okay. So I get it now. All right, so the $302,000 you got approved for, and you said Mr. Cooper, is that a company or the
Yes,
name of the company is Mr. Cooper?
Yes, Your Honor, that's the loan servicing company.
It's called Mr. Cooper. But who are you actually talking to?
The representative I'm working with, her name is Madison Duval, but she works for Mr. Cooper, who is serviced by Lakeview Loans. But that's the name of the actual mortgage company, Mr. Cooper. That's where I make the payments to.
Got it. All right. So you got approved. Their position is that that balloon that's attached to the house based on value to the house would remain. And obviously you would be responsible for on the sale. But since Mr. Knowles is attached to it as well, he has some concerns that he would still be attached to the balloon of the house, like a debt. He would still have a debt attached to the house. And he wants to clear himself of that. And your position is that the process is that once you have the home, then you can go to the company that has the note and place that note in your name because you have now assumed the house.
Yes, ma'am. And once I have the actual quitclaim deed to show that I actually own the property, then I will be able to go through the process of getting that note put into my name. And I just want to remind Jeremy that 25,000 of that balloon payment, we offered to deduct that. Actually, it's already been ordered that should be deducted from the final judgment. It was ordered that 25,000, half of that balloon payment, be deducted from the equity as well. That's in the final judgment.
I'm sorry, say that one more time. That's 25,000.
So half of the balloon payment, the final judgment reads that half of the balloon payment has to be deducted from the equity before, like as a part of his payout.
So that when you do sell it and that $50,000 is attached, his half would come because that's a debt.
Yes, ma'am.
Got it. Okay. And that $50,000 debt consideration is a part of the order already?
Yes, ma'am.
Okay. So essentially the court has dealt with that debt.
Yes, ma'am.
Yes, Judge. It's if the court wants to look at the final order, it's page 512.
Page 5 of the order.
It's number 2. I can have, if Rachel can put it on the screen if the court wants.
Okay, yeah, you can put it on the screen. That'll keep me from toggling screen.
Essentially, Judge, what we're asking is that you want the order that transfers her the house so he doesn't have to participate in this process.
So my concern about doing that, though, is that this is a final, and I don't know if I can make that large of a change. I can make changes that get to make sure we give the effect of it. So, for example, I can make him go to the closing and sign at the closing. That is what I can do, but I don't want to change the actual award because he's not behaving. Because there's a manner to get him to do what the order is intimating for him, or telling him, or intimating for him to do, which is basically to use the powers of the court for him to do that. But I understand your ask. Can I the $50,000 in covert relief? That one is also purely in just Jeremy's name.
Yes, Your Honor.
Okay, that one, huh? Okay. And do you happen to have that document where it explains that upon the sale, that's what you'll owe? Like, do you have that the note or the document that you signed regarding the $50,000?
Jeremy would have that.
Or from Cooper, is there any email from Cooper explaining how that $50,000 would occur? Like suggestions from them that the $50,000 would be handled, that you could handle that after the closing?
The email that I have from Mr. Cooper is basically my representative saying she's been fully approved for this loan. We only deal with the assumption. They're not really concerned with the balloon payment because the property's not being sold. I'm just assuming the loan.
You're assuming.
Mm-hmm.
Right. And okay, got it. All right then. Thank you. So let me go back to Mr. Knowles real quick. Mr. Knowles, you do recognize, and I think you have already indicated that you're not selling the property to her. This is an assumption, right? You understand that? So there isn't a sale. Do you understand that?
Yes.
Right. And this is generally just from my background understanding from other matters that I've handled related to these COVID balloon payments, that they normally attach to a sale. So a sale isn't happening.
So
like that's the debt you would owe upon the sale of the house, which I understand could happen at any point in time, and you don't want to be financially responsible for it. But by the same token, usually hopefully when you sell the house, you'll take that $50,000 note into consideration. But
so
I'm trying to get an understanding of what your concerns might be.
I totally understand. So allowing her to assume the mortgage, to remove my name from the title and deed, but still carry a bag, and the debt is actually $62,000, and still carry the debt of $62,000 and don't own the property or any rights to a property. So I owe money on something I don't own. I just want the full balloon payment paid off at closing. Like, into your order,
Do you
Miss-
have the documents dealing with this $50,000, $62,000?
yes.
You have it?
Yes, so I
wanna
got,
look at it.
when she started, well, almost finished the process, I got a letter from ISN about the balloon payment specifically, saying that it doesn't have to be paid off. But it, like, if I were to keep the house, I don't have to pay it off. But if she assumes the mortgage, then she has to pay it off at closing. So Mr. Cooper is calling the process closing, with transferring of the quitclaim deed, the ownership of the property, and removing my name from the deed and title and paying me out my equity at closing. But still, I would own $62,000 of debt, which can't happen according to HUD. Like, this has to be paid off if my name is no longer on the
Yeah,
primary.
So according to HUD, if this can't happen, because Cooper is saying it's happening. So if it happens with Cooper, what is HUD gonna arrest you? I mean, what penalties are you concerned about? Because other than it being a debt, which the court has already considered and indicated this is how this debt is going to be handled, what concern are you concerned about? What penalty are you worried about?
That I would own.
Because the court has already indicated how the debt is going to be handled. So what penalty, what are you worried about?
Owning a bag of debt, but having no claim to a property, and my future financial situation be affected because I have $62,000 of debt.
Okay. Can you send that? Can you send that document to me?
Yes, I will. Also, I want to.
You can send it to, do you have Ms. Marshall's email address? You can send it to her.
I
Make
do.
sure Ms. Bennett just copied on it.
Yeah. I'm gonna take a drink of water. Hold on.
Okay.
Also, with regards to the equity calculation of the payments, the appraisal was completed the day of closing. So on the 118th day of the 120 days, the court gave Ms. Knowles to complete the appraisal to calculate the equity. It was completed 2 days before the deadline that the court established.
I'm sorry, say that again?
Chelsea didn't get the appraisal for the house until the 118th day, or the day of closing. And the court gave me 10 days after she got the first appraisal to get a second appraisal. She allowed those two windows to overlap. So she was approved to assume the mortgage, but she wasn't able to remove my name per the order from all aspects of the home. And also she got the appraisal 2 days before the 120 days.
Well, you're using the word all aspects of the home. That's not what the order says. The order says is to assume the mortgage, and this is how we're handling the balloon debt. They're not the same. All aspects of the home is not what I wrote. I said the mortgage, and that the debt will be handled in this manner. The debt that's attached to the house will be handled in this manner. So I've already handled those issues. The only reason I am giving some time to this issue is because I'm concerned about your position on maybe a financial penalty that could be assessed against you, or some type of criminal issue that could come up as a result of dealing with the government. And I'm trying to ensure that that's not the issue. As far as the debt is concerned and how it's going to be handled, I've already dealt with that. That's a done deal. I'm kind of making sure that there is no other penalty that could be assessed as a result of this transaction that the court was not aware of. That's all I'm trying to do. Because I think the debt, the court has already signed it, and I already said mortgage and the balloon debt, this is how it's going to be handled. That's that. So I'm trying to make sure that there's no other penalties that are going to be assessed or some other danger related to how the process is working, that some other result or consequence, that's a better word, the court has not considered that could affect you. That's what I'm trying to figure out.
Yeah. Okay. So the question is, the closing, since it's assumption of the mortgage and removing of my name from the title and deed, how is it different than a traditional sale of the property?
It's not a sale. It's an assumption. That's the reason why it says assumption, because it's not a sale. You're just assuming the debt. So she's not selling it. She's assuming it.
Okay. And so she has her name already on the title and deed?
I'm not sure because I thought the closing didn't go through.
No, she already had her name on the title and deed before the assumption. The assumption process is just to remove my name from everything. She already
The
owns
assumption process removes your name from the mortgage, the debt.
Mhm. Yeah, she owns the home already. She's on the deed and title as a co-owner of the property.
All right. What's your question?
So handling this all concurrently versus congruently, did I read the order incorrectly? Like the 120 days to pay the petitioner and laid out the rules of how it all works? Did I read that incorrectly?
I'm not really certain about what point you're pointing out. So let me pull it up real quick because I don't understand what distinctions that you're making. Because I guess I'm stuck on the fact that you can't do anything if you don't close. So let me go there. Now, well, is it on the screen? Okay. Tell me what are you looking at that causes, what page do you want her to go to?
The top of the page 5. I think it's the top of
Page 5. Okay.
Yeah. So respondent shall have 120 days to assume or refinance the mortgage and pay petitioner 50% of the net equity in the marital as resident.
Okay.
So long as the respondent assumes or refinances the mortgage, the net equity in the marital resident shall be determined as. So to assume or refinance the mortgage and pay the petitioner 50%. Like that should be done at closing, correct?
Your Honor, may I?
Okay.
I think he's trying to go behind the order. And I also think he could have filed for contempt if he didn't get the payment on the 120th day, and he didn't. He tried to stop the entire process. So it was impossible for my client to pay him on that day. On top of which, Judge, we were trying to negotiate.
Oh, what you're saying is you were thinking that your money was supposed to come to you on the 120th day.
No. The equity calculation, the payout, I understand that the money comes later, but everything be clean and final at closing. Complete. Like things to happen concurrently versus congruently.
Okay. What is it that you're saying that caused a problem from that happening in the way that you perceived it to be happening, that you perceived it to happen?
Okay. So has 120 days to assume the mortgage. There's 2 mortgages on the property. She's able to assume the first one.
The second one is not a mortgage.
So
it's the debt. It's a balloon note.
So it's it's serviced by Mr. Cooper also, but there's no payments required.
Huh? Yeah, there's no payment required until you sell it.
Yeah. Yes. But it's also serviced by the same mortgage company, Mr. Cooper.
Okay. So let's not deal with those particulars right now. Tell me what's in the order that was not that did not happen. Because I've already indicated how I see that. To me, the fact that I already calculated that as debt, to me means I consider that to be debt. So we've already resolved that. What's the thing that did not happen?
So I guess that's my misunderstanding. So my name does not have to be removed from all aspects and debt related to the property.
It does not say all aspects. But go ahead.
So my name doesn't have to be removed from the second mortgage or the balloon payment.
It appears that when this issue came up, paragraph 2 is how the court handled it, which is that there's a COVID relief payment. That's a debt. So that's how it would be handled. But go ahead. We'll figure this out. Tell me what happened.
Like my name.
I get that part. We've already dealt with that. What did not happen?
Oh, she also didn't have the funds to pay me.
Funds to pay you what?
Or assume the property. Her lawyer, Miss Victoria, she sent me an email the day of closing saying that Chelsea cannot meet the order as written.
Stating that what now?
She could not meet the order as written.
No, Judge.
Not meet the order as written, i.e. they can't take out monies for this or that. Yeah, yes, I get that. They may not be able to give you what's in the order. They may have to give you, yeah, I get that because you're doing an assumption. So instead of a refinance. But anyway, go ahead.
Yeah, so she was able to refinance because she owns the property, a portion of the mortgage.
Say that again.
She was able to refinance a portion of the mortgage. That balloon payment, she's able to refinance solely in her name. She cannot assume that portion of the debt.
I don't think you can refinance that balloon note in your name. Are you sure that you can do that?
Yes.
Okay, let me show me where you're looking at that.
Okay. I'm looking for that document now, so I can send it to Ms. Marshall.
Because it doesn't feel like you can refinance that note because it's a debt. And I don't know how you refinance. I don't even know how that would. I don't know how you would refinance it. You're saying you want to roll it into the note?
No, she could assume the first note and then refinance the second note solely in her name to remove my name from all aspects of the property.
Okay, show me how is that done?
Yeah. She would take out a second mortgage on the property in her name only. And at closing, the balloon payment would be paid off in full, and she would own the equivalent amount of debt.
Yeah, I understand your logical run through in your mind, but that's just a run through. What legally can you do with that note? Because this is a note that's created by the government during COVID. And so the idea that it is connected to the house and that there is a lien connected to the note, I don't know if all of those things are in place that what you can do with it. So if your position is it can be done, I want you to show me how it can be done. Because to me, it's an odd thing because it's just a note and it never comes due if you don't sell your house. So I don't know how you refinance it if it never comes due or it comes due only upon the sale of the house.
Sorry. So it does come due in 30 years.
In 30 years. Okay. In 30 years, it comes due.
Yes. It comes due in full, like in 30 years or at closing when you sell the house. If the name on the deed and title change.
Right. So can you show me where you can refinance it? Can you show that to me? Yes.
So I connected Chelsea also with a different, as Chelsea stated, the person she was working with only works in the assumption department.
Uh-huh.
So I can work with a separate person in the refinance or mortgage department.
Okay.
So Chelsea with that person, both parties on the phone, to walk her through. And Miss Spanish wrote in her note that, I wanted Chelsea to refinance. I wanted Chelsea to refinance a certain portion, only this portion. And the way you do that.
I'm sorry, say that again.
So I wanted Chelsea to refinance the $62,000. That's it. And the way you would do that is you would take out a second mortgage only in Chelsea's name because her name is on the deed and title. She can take out a mortgage as long as I sign.
But when she does that, she'll be making payments on a second that this balloon or attachment doesn't require. So that's not the same. So the only way that this would work is that because you would have to show me that this program would allow her to put it just in her name. And it's the same program, that's one thing. But to require for her to get a second mortgage to make a second payment, because she would, unless you have one wherein it's going to also have the effect of doing the same thing. Because if she's going to have a note, that's not the same thing.
Can you give me 1 second to find this document and present it on the screen? It'll be like 1 minute. Okay.
You got to also be mindful that if I'm doing this mathematical gymnastics in my head, the 62,000, because I've already indicated you're going to pay 50,000. I mean, you're already going to pay 50% of this COVID money, and it's coming out of your net. If your position is 62,000, that means the court is going to pull 31,000 out of your net, and then she would basically refinance the other 31. So
100%.
Okay, so your position is that's what she should be doing, refinancing this last 31.
Yes, 100%. That's
Okay,
it. Yes, like to remove my name completely from all aspects of the marital residence. Like if
Okay.
she
what's the, what was the appraised value?
the appraised value, the appraisal that I got was 550, and the one that she got was 545.
Okay. All right. Are you presenting or showing me how you can refinance this balloon note?
Yeah, I'm downloading the partial claim subordinate checklist.
Huh?
I'm downloading the partial claim subordinate checklist by the servicer, and then also pulling up the note in regards to the claim. I have to log into their portal.
Okay.
Yeah. So it's just taking me a couple minutes. I'm sorry for the wait.
Okay.
Your Honor, I can move on to the other aspects of the contempt unrelated to the house.
Okay. Okay. Yeah, sure. I thought this was the biggie, but sure.
Biggie because it's time sensitive, but the others are part of our petition as well.
Okay, so but let's just give him so that he can participate and listen when you go through the other matters. We're gonna take a 5-minute break, and that'll give him a chance to pull those other issues and send them to Ms. Marshall so I can take a look at them. This concept being new to the court. Ms. Sterling, Ms. Austin, if you'll come to my office.
Okay, Ms. Knowles, you're still under oath. Okay, we're going to continue your testimony. In the
Hey guys, welcome back to my channel. Today I made this wig. It's so cute.
What's that?
But
no.
Sorry, I think I clicked on something in the background.
Oh, okay.
Okay, was Mr. Knowles ordered to pay $901 in child support each month beginning on 2023 as part of the temporary order, which was substituted for 810 in the final judgment?
Yes.
Oh, I'm sorry. Okay. Did he, and he was ordered to pay $901 in the final judgment, is that correct?
Yes.
Okay. And has he made those payments as ordered?
No.
Okay, I'm going to show you, Ms. Newell, if you could put up Exhibit E. Does this spreadsheet accurately reflect what Mr. Knowles paid and what Mr. Knowles didn't pay in terms of child support that he owed?
Yes.
Okay. Did I prepare this and show it to you to make sure it was accurate?
Yes.
Okay. Is it accurate?
Yes.
Your Honor, I move petitioner's Exhibit E in for identification.
He so admitted.
Okay. Now, Chelsea, did Mr. Knowles, in October, November, December, he owed $810 because of the temporary order. Is that correct?
Yes.
And he only paid payments of $967 and $300 during those 3 months. Is that correct?
Yes.
And then for January, February, and March, and April and June, did he make any child support payments in the amount of $901?
No.
Okay. Did he pay $2,500 as a lump sum in May?
Yes.
Okay. So the total he owed versus minus the payments he made leave $4,069 owed to you in child support. Is that correct?
Yes.
Okay. Are you asking for the court to find Mr. Knowles in contempt for failing to pay the payments as ordered?
Yes.
Okay. Mr. Knowles also was ordered to pay $3,963.52 within 10 days following the entry for unpaid school fees. Is that correct?
Yes.
Has he made any payment on that?
No.
And Mr. Knowles was also ordered to pay 40% of all fees related to the minor child's tuition. And at the time of the final judgment, that amount was $5,725. Is that correct?
Yes.
And since then, for the next school year, has Mr. Knowles made any payments as ordered towards the child's tuition?
No.
And is that amount already due?
Yes.
Okay, Ms. Newell, if you could please pull up Exhibit G. So, Your Honor, I'm going to move petition. Is this in a spreadsheet that I prepared with your assistance?
Yes.
Okay. Your Honor, I move petitioner's Exhibit G into evidence into evidence.
Okay. Any objections? So admitted.
Okay. let's go to the middle part of that. School fees owed for the final judgment was $3,963.52. Do you see that?
Yes.
Okay, plus the $5,725 he owed at the time of the final judgment, correct?
Yes.
And since then, what are the current fees he owes for Wynn's school?
$6,498.
Okay, and those have been unpaid, is that correct?
Yes.
Okay. The attorney's fees that he was ordered to pay in the amount of $18,649.48, did he ever pay those?
No.
Okay. And he owes you 50% of Wynn's medical bills in the amount of $148.53?
Yes.
He failed to pay that as well?
Yes.
Did you ask him to pay it?
Yes.
Did Mr. Knowles at any point take the child out of the state without letting you know he was going out of state?
Yes.
And what happened?
Unfortunately, one of Jeremy's close family members passed away, and Jeremy let me know, and he told me there were 2 services available. He did mention that one would be held in Atlanta, the other would be held in New York. He specifically said that he would plan on attending the Atlanta ceremony, because it was going to be similar to his late grandmother's ceremony that was also held here in Atlanta several years ago, and that he didn't see the need to travel with Wynn to New York.
Then what happened?
He ended up going anyway, and I didn't find out until he had traveled about 48 to 72 hours later, and where he dropped me a pin, just a random pin with a location that was unknown. He didn't tell me when he was traveling. He didn't tell me who he was traveling with, nor where they would be staying. And then I only found out because I was FaceTiming with Wynn, and I asked her what she was doing and where she was, and she just seemed really confused. It's almost like someone was coaching her on what to say. And then I asked him where they were, and then that's when he dropped the pin.
Okay. And did you immediately say, why are you in New York?
Yes. And he's like, I told you what was happening. I told you I was taking her, and that's not the case.
Okay. Did you have a chance to review the correspondence with him before that to make sure you didn't miss something?
Yes.
Okay. And did you miss anything?
No.
And he verbally told you he was going to the Atlanta one and never told you he was going to the one in New York. Is that correct?
Yes. And even invited me to pay my respects at the Atlanta one.
Okay. Did he ask you to prepare Wynn for anything?
No.
Okay. When you were starting the assumption process, you needed clearance for you to be able to contact the mortgage company. Is that right?
That's right.
And did he provide that to you as ordered?
No.
Jeremy was also ordered to obtain life insurance in the amount of $500,000. Is that correct?
Yes.
And has he provided you with any documentation?
No. And I have asked him about it, and we did briefly discuss me potentially. I know he said it would be a financial burden for him. So I did ask him if it was possible that he would allow me to take out a policy with Wynn being the beneficiary. And he agreed to do like a living, I forget what it's called, like a living insurance policy where the living beneficiary could take out, like, say he was diagnosed with like a terminally illness or disease, then the person diagnosed could potentially take out a portion of the policy, but we have not been able to come together on an agreement with that. Obviously, there's a lot of.
So you asked him if you could pay for the $500,000 insurance policy with Wynn as a beneficiary.
A different policy, not the one that he was ordered to get. I wanted to get my own policy in addition to that one.
Oh, okay.
He was ordered by the final judgment to get his own just for Wynn, but I wanted to take out one with me and Wynn as a beneficiary. And that's the only one that I offered, but he still needs to get, his own $500,000 policy that was ordered by the court.
Okay. I want to show you G again. Okay. You had the appraisal done, which came back at $545,000. Is that correct?
Yes.
Okay. And Jeremy said he had his own mortgage done, and that was for the appraisal was $550. Is that correct?
That's correct. Yes.
Did he provide you with the entire appraisal when you asked him for it?
No.
Okay. Did he say why he wasn't going to give you the entire appraisal?
No, he told me he was only going to give me what I needed or what he thought was appropriate.
Okay. The principal mortgage balance as of October 1st, which was the date it was supposed to be calculated by, was $302,130.46.
Yes.
And because of the order, it was to deduct 50% of the COVID relief payment of $25,000. Is that correct?
Yes.
You had to pay $3,013.50 for the cost of the assumption,
Yes.
and you had to pay $1,000 for the cost of the appraisal. Is that right?
Yes.
Which would bring the net equity down to $213,856.04. Correct?
Yes.
And 50% of that would be $106,928.
Yes.
Jeremy was also ordered to provide 50% of the repairs that he had made, which were wrong, into the marital home of $20,044.38, right?
Yes.
So the equity for the final judgment would be, after reducing all of the things that were required by the court, it would be $86,883.64, correct?
Yes, correct.
Okay. And then did you and Jeremy enter into a discussion to take the money owed, because you weren't getting it, out of his portion of the equity?
Correct.
Okay. And so then if you see the reductions by the amount that we've already discussed and the credit of $2,500 that he paid towards child support, that amount would be $47,978.64. Is that right?
That's correct.
And then minus, again, the medical bills. So the total due to Jeremy so far would be $47,830.12.
That's correct.
And you were prepared to make arrangements to have that paid after you had the home.
That's correct.
Now, did Jeremy mention anything about a balloon payment as the reason he wasn't going to the closing? Or did he just say that you weren't going to pay him his equity on that day?
Correct.
Which one?
He told me he wanted to have his equity paid at closing, and that's why he did not show up.
Okay. And
he did not mention.
You had emails to that effect. Is that correct?
That's correct.
Rachel, if you could please pull up, starting with Exhibit N. So as in this, your closing was going to be April 26th, right?
Yes.
Okay. And that was a day before the 120 days.
Yes.
Okay. So did you and Jeremy exchange emails on Monday, April 22nd, 2024 at 6:58 p.m.? I'm showing you what's been marked as Petitioner's Exhibit N for identification. Do you recognize it?
Yes.
Okay. Is that an email between both of you?
Yes.
Okay. If we can scroll down, please. Jeremy, in this email, a little higher up, please. Thank you. Jeremy told you what the challenges he had regarding any of the closing. Is that right?
Yes.
Did he mention a balloon payment or a second mortgage in any of these in this email?
No.
And in fact, he was trying to get you to sell the house or him to sell the house on May 1st. Is that right?
Yes, I got multiple threats sent to me about him selling or entertaining cash offers because I was coming up on the 120-day deadline.
Okay. And just to back up a little, when did you first start asking Jeremy to help cooperate with the assumption process?
I first started back in October of 2023. But while we were waiting on the final judgment, they closed out the file because they needed the final judgment and divorce decree to start the assumption process. So once that was closed, I did reopen the case for the assumption in January. And I still had to call multiple times to get authorization to even speak. I had to have Jeremy on three-way to allow me to speak on behalf of the assumption. And I had to get him to sign paperwork to allow me as a third party authorized person to start the assumption process. So that required us to meet. And we weren't able to meet until February due to scheduling conflicts and Jeremy's availability.
Okay. So it was about a month that it took just to get the process restarted because you couldn't get Jeremy's signature?
Yes. And then when I opened the process, he kept saying he hadn't received the welcome package. I called the mortgage company literally every single day and they would tell me, oh, it's been sent. But Jeremy had all of his mail forwarded to his new address. And I asked them, well, can you send it directly to me? They said no, because you're not on the mortgage. So it was just this huge loophole of me calling Mr. Cooper, calling Jeremy, telling them I haven't received the paperwork. Jeremy saying he hasn't received the paperwork. And finally, we were able to get the process started when Jeremy scanned the documents over to me. I ended up just using the old documents that Jeremy scanned back in October.
Okay. How far did that put you behind in the assumption process?
Several weeks.
Okay. And once you started the assumption process, how long were you told they normally take?
5 months.
Okay, so at the beginning of this, you knew you were going to be right up to the edge of the 120 days, right?
I did, and that's when I reached out to you all.
Okay. So, Your Honor, I move Exhibit N into evidence, if it hasn't already been.
So admitted.
Thank you. Okay, can we move to Exhibit O? Okay, is this the day before closing?
Yes.
Okay, I'm sorry. I'm showing you this for identification. What is it?
This is the closing documents that Jeremy required me to send him prior to showing up for closing.
Okay, and did you show them to him?
I did.
And in fact, acknowledged this the day before closing and sent it to somebody KW for legal review. Is that right?
Yes.
Okay. Your Honor, I move Exhibit O into evidence.
So admitted.
If we can go to P. Okay, so this is still, I'm sorry, I'm showing you what's been marked as petitioner's exhibit P for identification. Do you recognize it?
Yes.
Is it an email between you and Jeremy?
Yes.
Okay. I mean, there are other people on this, but you and Jeremy are communicating on this. Is that correct?
That's correct.
Okay. So tell me what this email is about.
So this email is about Jeremy not cooperating with the assumption process. We went back and forth about equity. Ryan Holmes from Keller Williams had been involved, who never responded to any of the email correspondence. So I'm not really sure what his part was in the process. I had Mr. Cooper involved, and Jeremy's concern was about not showing up because he wanted to make sure that his equity was going to be paid. Basically, he wanted to have a check hand delivered to him at closing for him to show up to closing. But
now, sorry, go ahead.
I was just going to say we couldn't even agree on an amount to pay for equity. So it was just, we were just at a standstill. So that's when I forwarded this email over to you.
Now, today, you heard Jeremy answer the judge when he said that it had nothing to do with the not getting the equity on that day, but it was only about the balloon payment that he was concerned about. And that's why he wasn't showing up to closing. Is that right?
Yes.
Is that true based on what he was emailing you at the time?
No.
Okay. When's the first time he mentioned anything about a balloon payment to you? Was it after the closing had expired?
It was, yeah, it was definitely after.
Okay. Your Honor, I move petitioner's exhibit P into evidence.
Please so admitted.
Okay. If you can go to Q, please. Okay. Showing you what's been marked as petitioner's exhibit Q for identification. Do you recognize it?
Yes.
Okay. Is it an email between the two of you the day before closing?
Yes.
And what does it say? Well, Your Honor, I move petitioner's Q into evidence.
All right, so admitted.
What does it say, Chelsea?
This email is from Jeremy. He said, if you are not able to secure the monies to finalize the assumption and transfer of the deed, I would like to put the home on the market starting Monday so we can both move forward with our lives. Thank you, Jeremy.
Is there any mention of a balloon payment in here?
No.
Or a COVID relief payment?
No.
Okay. Just he wanted the money, the equity, because he thought it had to be paid on that day. Is that right?
Yes.
Okay. Even though he told the judge today that's not what that he understood that it couldn't be paid that day.
Yes.
Okay. If you could
Let
go
me
to
ask you a question with regard to since you're assuming and there is funds that you have to pay him, what was your plan? What was happening to ensure that you would be able to pay the payout? What were you doing?
So we got to a point, Judge, where Jeremy and I talked and we were like, if we could get to a number, I was prepared. And I even had to show Mr. Cooper that I had money available to pay Jeremy at closing. I had to show that I had funds available using my 401k to show that I actually had the money for closing. And I told Jeremy that, and he still didn't show up. I was fully prepared to pay him his equity based off of the calculator that we just presented that showed all the things that would be deducted that were ordered by the
But outside of those deductions, were you able to pay it?
Yes.
So even if you didn't make those deductions, you would have been able to pay him this, what was that? 80 something thousand?
Yes, I was prepared to take out money from my savings to pay him.
Okay. All right.
And certainly had, well, excuse me, we'll move on. Can you put up T, please? I'm showing you what's been marked as petitioner's exhibit T for identification. Do you recognize it?
Yes.
Okay. Is it an email between you and Jeremy, or you, Jeremy, and Victoria from my office on April 30th?
Yes.
Okay. And this is after Jeremy didn't show up at closing.
Yes.
Okay. What does this email say?
Hi, Victoria. Just following up on my email from yesterday. I just got off the phone with Chelsea and she let me know you have the calculations prepared for the equity payout. If we were to use the appraisal Chelsea got on Friday, minus the court fees, child support, etc., she let me know that the payout is around $16,500. Please send these numbers over so we can begin the process of closing. Underline in bold, I agree to have all fees subtracted from my portion of the equity.
Okay. So let's discuss what that means. We had also filed a 9/15/14 motion for attorney's fees. Is that correct? As a result of the trial.
Yes.
And that amount was in about $28,000 that we were asking for. Is that right?
Yes.
For Jeremy to get down to that 16.5, did he include that 28,000 as owed to you?
Yes.
Okay. So as far as you were concerned, had he showed up at the closing, you could have written him a check for $16,500.
Absolutely. And I let him know that.
Okay. Now, Your Honor, I move petitioner's T into evidence.
I'm sorry.
I move petitioner's T into evidence.
Still admitted.
After the missed closing, did Jeremy send the code violation crew out to your house?
Yes.
Can you explain what that was about?
It caught me by surprise myself. So I actually had to call the officer that was listed on the notice. And the officer stated that I had an outlet moved from my living room and I was in code violation. And I let the officer know that wasn't true and that I'm being harassed by my ex, who I am about to go to court with over the ownership of the house. And I explained that to him. He said he knows how messy divorces are. He said we still need to come by and take pictures and just make sure that everything is up to code. And he said, let me know when you're available for me to come by. And that was the end of that. I didn't get any fines. I didn't get any citations, anything like that.
Do you know who called code enforcement?
Jeremy.
Right. Did you discuss it with Jeremy?
No.
Did you have to retain us again, or never stop retaining us? Did you have to employ us for purposes of handling the closing and the contempt and the 9/15/14 from the previous litigation?
Yes.
Okay. If you, Ms. Newell, if you could pull up Exhibit X. Okay. I'm showing you the first page of Exhibit X. Do you recognize it, Chelsea?
Yes.
What is
Yes.
it?
This is a ledger of attorney's fees that I incurred from going back and forth with Jeremy about closing and just trying to get everything finalized so we can move on. But there was a lot of back and forth, and Victoria and Esther had to jump in quite a few times to try to get this resolved.
Okay. And Ms. Newell, if you can scroll down to the end. Okay. Now, to be clear, this was done after the 9/15/14 motion had already been filed. This did not include any of the things from the trial litigation. Is that right?
Correct.
Okay. This is just to handle the contempt and the motion for emergency hearing. Is that right? And preparing for today.
Correct.
Okay. What is the grand total that you have spent between the petition for contempt and the motion for emergency hearing and preparing for a trial?
$9,561.21.
Okay. Your Honor, I move Exhibit X into evidence.
Still admitted.
If you can move to Exhibit Y, Ms. Newell. So what is this?
So this is a equity payout calculator showing what would be due to Jeremy after closing
Okay.
or at closing if he ever signs the papers.
Okay, so if the court finds Jeremy in contempt for this action and assigns attorney's fees for it, are you asking that that be reduced from his equity?
Yes.
So the 9,000 you just mentioned, $9,561.21. That's broken down here. Do you see 6,032.46 for the contempt, 1,846.88 for the emergency hearing, and then hearing prep through what's today? Friday, through Wednesday. Is that correct?
Correct.
And so without putting in yesterday's prep and today's hearing, if you reduce that from the 47,830.12 that was from the other spreadsheet, the total due to Jeremy would be 38,268.90 cents.
Correct.
Okay. And he had previously said that you could resolve, or he would pay the 915.14 fees that we had filed, but we hadn't litigated yet. Is that right?
Yes.
Those are $28,115.07.
That's correct.
And so what would you totally owe Jeremy as part of his equity if, once the house is assumed, once the mortgage is assumed?
$10,153.83.
All right. Is that what you're asking the court to enter as the amount of equity that's owed Jeremy at closing?
Yes.
Okay. Your Honor, I move Exhibit Y into evidence. Are you asking the court order Jeremy to attend the closing and sign the documents necessary to permit the assumption to go through?
Yes.
Okay. I don't have any further questions for her. I do have an attorney's fees. I have to stand in my place, Judge.
All right, Mr. Knowles, you have any questions for Ms. Knowles?
Before we get started, can I submit or can I share my screen?
Yes, you can share your screen, but make sure this is something you're showing related to her. If it's something that you want to present yourself, you'll have the opportunity to do that when you get ready to present your.
Okay, thank you. I just wanted to share this. During Mrs. Knowles' testimony, I went into Bank of America and pulled up the actual transfers that I made, payment by payment. So they were missing this 1020 payment.
They're missing what now?
They're missing the 1050 payment in their calculations.
It was on there.
Oh, okay. Can you stop sharing real quick and let me ask Miss Rachel to pull up that one, the other one, so we can see the difference real quick. Miss Rachel, so Miss Marshall, you have to switch real quick. Or do you have to? I think you can put both of them. Okay, as okay. Can you go to the so the 1050 looks like arrears per final order. There's a 1050 there, but I'm not sure. Okay, those were arrears per the final order.
Judge, I can show it.
You didn't attach as doing owing.
No, we showed that it was paid on October 10th.
Okay, it was supposed to be paid on 12/29. The arrears says that's what he was supposed to pay, and these are all new and upcoming amounts, and that amount was what was an arrearage.
Correct.
Got it. Okay, makes sense. Okay, now go back to thank you. You can stop sharing. Okay, you can ask questions related to that or proceed.
Yeah. So in total, the payments you've received for Mr. Knowles or myself since the final hearing have been closer to $4,200. Is that correct, Mrs. Knowles?
We just showed you the amount on the last document, so do you want me to total them up for you?
No, that's fine. I have another question. Ms. Knowles, how many schools is Wynn currently enrolled in?
1.
How many schools have you paid a retainer to?
1. I paid a deposit for a summer camp that she's in, and she has a spot that's being held at her primary school.
Okay. And how much combined are these both in total for the year? Because in my understanding, the second summer camp, as you put it, title is, can you say the title of the summer camp?
Brilliant and Kind Montessori.
Okay, so it's a Montessori school?
Mhm.
And how much is it per month?
It's $14.25 per month.
Okay, and how much is our other Montessori school?
So her other Montessori school, Carlisle Montessori in Buckhead, as you and I both discussed, we have considered enrolling her full-time at Brilliant in Kind Montessori, given the summer program is successful and she likes it. And we have her full-time enrollment would start in August, once you and I make a decision. Right now, yes, I did have to pay a $13.25 deposit at Carlisle Montessori of Buckhead to hold her spot in case it doesn't work out at the summer camp program.
Did you just pay a deposit or did you pay 60% of the full year?
I paid a deposit at Carlisle Montessori because you told the school that we were going to get back to them regarding your 40%. So we have not gotten back to the school regarding your 40%.
Okay, in total, if you were to add up the annual fees of both schools combined, it's around $21,000. Would that be incorrect?
Your Honor, I'm going to object. She said that she's only enrolled in one school.
I know, so I don't know what that question means. I'll let Ms. Knowles answer it to the extent she can.
Yeah, she's only enrolled right now at Carlisle Montessori. She's at Brilliant in Kind Montessori for summer camp. We have not enrolled her full-time at Brilliant in Kind Montessori, which you're aware of.
Okay, so she's not enrolled in Carlisle's Montessori at all.
Yes, she is. That's her full-time school where she's been going since she was 18 months.
So she is enrolled in two schools.
She's at summer camp at Brilliant in Kind, which I've already paid for, which you have contributed nothing to. And she has a placeholder where she's enrolled at Carlisle Montessori, where she's always gone to school. That's the only school she's ever gone to.
Okay. So were you notified of the assumption paperwork on October 23rd?
What do you mean notified of the assumption paperwork?
That it had been received by me? Did I text you?
Honestly, I don't remember the exact date.
Okay. Can I share my screen again?
Yes.
No, I'm asking the judge.
Oh, yeah, you did, sure.
All right. Can you read this text message to us? Just the first line?
Your Honor, it hasn't been admitted.
I'm sorry?
It hasn't been admitted unless this is one of mine.
No, this does not look like anything I've seen from you. So, Mr. Knowles, ask her if she recognized it and if it's correct. And if it's correct. And that's the only way it could be admitted.
This text message, and is it correct?
I do see the text message, but I don't see the date that was sent. And you never brought me the documents that night. You actually brought me the documents in November at her soccer game.
So is it your position? Is it true and correct? Like, can you see the information? Are you true and correct? That the court can review it.
Yeah.
Yes, this is a text message between me and Jeremy.
Okay. You need to leave it up now because I need to look at it. Okay, you bet. Okay, I'm sorry. I thought it was. Okay.
What's happening?
I'm looking at it.
Oh, okay.
Okay, so what's the issue? What's the point on this one?
The point I'm making is that she's been fully involved throughout the assumption process.
Who's been involved?
Chelsea has been involved. And been
At what now?
Chelsea has been involved through the entire assumption process.
I get that. She's doing it. What do you I'm confused. What's the point of this?
The point, I guess that Chelsea has been involved, that I haven't delayed the process at all.
Chelsea has been involved
throughout the assumption process. For the full process.
What was the position that she wasn't involved? How could she not be involved?
She is saying that I never notified her of the balloon payment at the end.
What balloon payment?
The second mortgage on the house.
I know. Where is that in here? I don't see that. Unless I'm not reading it, I just see you said, I got the assumption papers, and that's everything else is about a party.
Okay. Yeah. So once I received the papers, once we signed the papers.
Okay. Yeah. Is there something in this text message related to the COVID relief balloon?
There is not. No.
Okay. That's what I'm trying to figure out. If there's some portions to it I can't see, because the only thing I see is that you said you got the assumption papers in the mail, and how is your equity going to be paid?
Mm-hmm.
Okay. All right. Okay. Thank you.
I'm
going to admit this in.
Okay,
So what number are you gonna call it?
Exhibit B.
Okay, Exhibit B. All right.
Yeah.
So admitted.
And Chelsea, in the flurry of text and emails that we have gone back and forth throughout this process, have you identified or put in writing anywhere where you plan to pay out my equity? Like after the assumption process, like at closing, have you wrote that down anywhere? Or would you say it just been a conversation between you and I?
Can you close out this document since we don't need it for that question? Stop sharing.
Yeah, I'm looking.
We actually have submitted several of our email chains with the payment calculator, and we were never able to agree, Jeremy. You never said, when we went back and forth about the equity, you never said, I agree to this number. So how could I know what to write on the check to say, I confirm this is what's going to be paid to you? We never came to an agreement. We always went back and forth, like you just said, through the flurry of emails. We never came to an agreement on a number.
Okay, so we never agreed that I would pay the 19-15-24?
You said that it could be taken out of the equity. You never said.
Never agreed to that, from what you're saying.
No,
Correct.
you didn't agree to it. We just saw the email where you agreed to it that I just read in my testimony.
Okay, so we did agree on a payment or amount?
You never agreed to a number that you were willing to pay. No. Or that you were willing to accept. No, you didn't. You said that's why you didn't show up to equity. In your last email, you said, I forget exactly what you said, but it was about the equity. And you never agreed to the amount that we presented to you in the calculator. You never agreed to it. And you said that's the reason why you wouldn't show up.
Okay, and why didn't I agree to it?
I don't know. You never said.
So you can say that I didn't agree to the document in whole or the calculation you guys put forward.
I'm not sure what you were thinking.
No, I'm asking, do you say I agree to the whole document?
What document?
The calculations?
I don't know. Do you agree with what we just presented? The 10,000? Do you agree with that?
I do not agree with the documentation that we put forward, but I'm asking you. You said that I didn't agree, but we came to an agreement?
The agreement we came to was when you stated in the email that we just showed the judge, you said that I agree that child support, tuition, medical payments, and attorney's fees could be taken out of the equity. That's all you agreed to.
Yeah, okay. And we established equity through an appraisal, correct?
Yes.
Okay, so it was just the equity in the home minus the outstanding fees that I agreed to, correct?
No, in your last email, you said child support, you said tuition, you said attorney's fees. You said all those things in the email we just showed.
Okay, so I did agree to a number.
The $10,000? Is that the number you're stating? Which number? I know it's been so many
I'm
numbers.
asking, did I agree to a number?
Jeremy, you didn't agree to any numbers. That's why we're here.
Okay, and can you show me somewhere in writing that you agreed to pay me through your retirement account, through taking out a loan against the property? Do you have anything showing that?
So if the concern is that you wanted to be paid equity at closing, we actually have to, like I told you before, we have to close on the property for me to pay equity. I can't pay equity for a property that I don't own. I told you I was fully capable and able to do that. Like, the means of those funds are frankly my business, and I presented that documentation to the loan company. But no, I didn't send you statements of my bank account to show you that I had the money. No, I didn't.
I'm not asking for that. Did you show me any evidence that you were going to pay me?
Jeremy, you and I talked multiple times, and I told you I was prepared to pay you.
Okay. Is your name on the deed and title of the home?
Yes.
So when you say you don't own the home, what do you mean by that exactly?
I don't own the mortgage.
Okay, do you have to own the mortgage to own the home?
Your Honor, I object for relevance.
Yeah, next question.
Okay. Do you currently own the home?
Objection, Your Honor.
Go to the next question.
Is your name on the deed and title?
Objection asked and answered.
I don't even understand the need for that, Mr. Knowles. I mean, what point are you making on the contempt? She you know she didn't close on the home. And so why are you asking? You know she did not close on the home. How can you possibly ask her those questions? That's ridiculous. Go to something else. You know she didn't close on it. So therefore, the notes are going to be in your name. Everything's going to be in your name. Why are you asking her that?
Okay, can I show another thing?
Sure.
With
Just
documents?
make sure it's relevant. I don't have time for you to ask questions that you know the answer to and that everybody else in here also knows the answer to, because it's the very reason we're here.
Okay. Ms. Knowles, can you identify what's on the screen right now?
Your Honor, I'm going to object. It's exactly what the court just told him.
Okay, is this a document that was presented at closing? So if it is, and she recognizes it to be the same, he can answer. She can proceed. He can proceed.
Yes, it's a quick claim deed.
Okay. Whose name is on the deed of the house? The two parties that are identified as the grantors?
Jeremy Knowles and Chelsea Denise Knowles.
Okay, and who are we collectively selling the property to?
Well, if you scroll up, it says a transfer of property from through a divorce or something. Can you scroll up a little bit?
Can you answer my question first?
I am in.
What is the question? What's the
Whose
question?
name is next to grantee? Who are we selling?
I can't hear you.
Who are we selling the property to, Chelsea?
We're not selling the property.
Okay. But your name is on the deed.
This,
Okay.
yes, this is the transfer. What's the question related to it?
Okay.
What's the question related to this deed? What's the issue with this deed that I'm looking at it for?
Nothing is wrong with the deed. The reason I'm showing this is to show that Chelsea owns the property.
You all signed this deed.
No. Well, she owns the property when we bought the house. Her name was on the deed initially, deed and title. Only my name is on the mortgage, but her.
Oh, okay. I see what you're saying. You're saying that at some point you put Chelsea on the deed?
Yes, when we bought the house initially. She's always been on the deed and title.
Oh, okay. So for some reason I thought you guys bought this house before you got married.
We did before we got married, but I always put her name. I put her name on the deed and title at closing when we bought the house.
Oh, okay. I see what you're saying. All right. So, okay. All right. Go ahead.
Yeah. So who is the
So
grant?
where's the original deed that you have her name on?
I don't have the original deed in my possession. This is the closing documentation that shows who was on the deed and who's only going to be on the deed.
Okay. Okay.
Can I admit this as evidence?
Yes. On what number?
J, Exhibit J.
Okay.
Okay. Chelsea, did you ever inquire about taking out a second loan on the mortgage or on the house? Sorry.
No, because I don't own the mortgage, so I can't take out a second mortgage.
Do you need to own the mortgage to take out a second mortgage, or do you need to own the house to take out a second mortgage?
So my understanding is, since I don't have a lien holder, like how can I take out a second mortgage when I don't have a first mortgage? You own the first mortgage.
Yeah, okay. So correct me if I'm wrong, but you take out a mortgage on a property because that's what they can, I guess that's the physical asset versus you don't take a mortgage out on a mortgage.
Okay, listen, I can't go through the idea of you all trying to educate each other on legal issues dealing with this document. I don't. So you can ask her, Chelsea, were you aware, or at least it is my understanding, that you could have taken out a second. Why didn't you do that? And then she'll say, I can't, and then you'll move on. Because
all right,
idea that you guys are trying to jump through legal issues, to me, it's painstaking. I just can't take it.
Yeah. Okay, so Chelsea, were you able to take out a second mortgage on the property?
I'm
No,
going to object to relevance. She didn't need a second mortgage on the property.
I'm gonna let him finish. Okay, go ahead.
That's it.
All right.
The next point about the taking went out of state without notification. Did I call you to tell you that Marquise died?
actually, you just sent me a picture of like a notification of a funeral, and then
Yeah.
I called you and
Yeah.
asked you what happened and expressed my condolences.
Okay.
And who was it that died? Maurice, who is that?
Marquise, that's my first cousin.
First cousin, okay.
But does this document have the address of the funeral?
I can't see it, but yeah, I can't. Yeah, I can't see it, but I do remember you telling me that there were 2 funeral locations in Atlanta and New York.
Okay. And was it my weekend for the first funeral? Or was it your weekend?
For the first funeral, honestly, I don't remember.
Okay. Did I can remind you it was my weekend. Did I
For
offer
the Atlanta funeral or the New York funeral?
your funeral?
Okay.
Yeah. Did I offer to switch weekends since it made you uncomfortable that we would be traveling on such short notice?
We never even talked about you going to the New York funeral. You just told me that there were 2 services. One was in New York, one was in Atlanta. And you said you were going to do the Atlanta one for convenience and because it was going to be like the same place where your grandmother was buried.
Mhm. Okay. And you said that I sent you a drop pin 48 hours after, or 48 or 72 hours after I got there?
Will you repeat the question?
You sent a drop pin 48, or I sent a drop in 48 to 72 hours after I got to the funeral?
Well, I don't know where you were at. All I know is just I got a drop pin like 1 or 2 days after you were traveling. Like I
Okay.
don't even know I don't remember when you said you went. I just know, I think you sent it to me like on a Sunday. I don't remember exactly like when the funeral was. I just know it wasn't the day of the funeral. I was just very confused and out of the loop. And I had no idea that you were leaving and taking Win with you to New York. No idea.
All right. And I'm just gonna replay a timeline. So you drop Win off to school Friday morning. I pick her up Friday afternoon, and she's back in school for Monday morning. So the whole weekend itself is less than 48 hours, from start to finish is 2 days. So we left Georgia or Atlanta late Friday night. We arrived the day of the funeral. You FaceTime Win. I sent you a drop in, also emailed you the flight itinerary. And then we flew back on Sunday morning. So we were in New York less than 48 hours, and she was back in school on Monday morning.
Like my issue was you never told me what the plan was. Per the order, you're supposed to say where you're going, if you're taking her out of state, and who you're traveling with. None of that happened. You're saying you sent me a flight itinerary. Do you have a copy of that? Because I never got it. All I got was a random drop pin in New York. And then I'm FaceTiming Win, and she's confused, and you're telling her to say certain things on the phone. It was just a very weird situation. All you had to do was communicate to me,
All right.
as I would do for you.
So you FaceTime Win the morning of the funeral.
Mr. Knowles, can
Yes.
you, I can't, it doesn't even matter. Can you, the order says to let her know. Do you have the text message or whatever it is that shows you did that? That's all we need.
Okay. So yeah, I notified her of the funeral via the text message. She called me. We talked on the phone. I asked her to do Wednesday or nice. I also offered to exchange weekends because it was in short notice. Yes. So all of that.
All right. Is there any text message wherein you tell her that you are taking Win on this vacation or even evidence of the flight itinerary that you said you sent to her? How'd you send it, text or email?
Sent it directly from the Delta portal.
What now?
I sent it directly from the Delta portal.
The
When I
Delta
booked the
portal?
flights portal. When I booked the flights, I included her email address.
Oh, okay.
Yeah.
I never got it.
Yeah. So essentially, I'm just showing that we talked about the funeral. She was aware. The location, it was short notice, rushed. I informed her to the best of my ability from the beginning to the end.
Okay.
In regards to the code enforcement, I guess I would just talk to you, Judge, instead of asking her questions. It's not really
Okay, because if you don't have any questions, then you can bring these things up for yourself.
Okay, yeah. Then no more questions then.
All right, thank you. Do you have any follow-up questions, Ms. Panich? You're on mute.
Sorry, Judge. I don't have any further questions for my client. I would like to request a 5-minute comfort break.
Okay, right now?
Yes, please. I didn't
Okay.
want to-
That's fine. Did you send did you send that exhibit list to the court? Your exhibit list, Ms. Panich?
I don't know if we sent the list. We sent the exhibits, but I
Yeah,
can send the
that's
list.
fine.
I can
You
send the
sent
list.
No, I just wanted, I wanted to, during this comfort break, go back over those exhibits. Ms. Marshall would have them. Ms. Marshall, did you forward those to me? And if you would forward those to me, thank you.
Yes, ma'am.
Your Honor, would you like the actual list?
No, I don't need the list. I just wanted to see the documents. Thank you.
Okay.
We'll take a 5 minutes.
Thank you.